Hello, everyone. I want to start this Zoom call by acknowledging that I am talking to you from the Australian National University, which is in Canberra, on the traditional lands of the Ngunnawal and Ngambri people. I want to pay my respect to the elders of these lands and acknowledge that law has been practiced on these lands for thousands of years, long before we have come along to teach our version of the law. And finally, I want to acknowledge that sovereignty over these lands has never been ceded. Welcome everyone to this event. My name's Imogen Saunders and I'm the Director of the ANU Centre for International and Public Law. It is my great pleasure to welcome you to this exciting In Conversation with the Honourable Michael Kirby on the United Nations Commission of Inquiry on Human Rights in North Korea. And I'll hand over now to Richard to welcome our special guest.
Well, thank you very much, Imogen, and good afternoon, everyone. We are really honoured, Michael, that you've agreed to once again engage in this In Conversation event focusing on international dispute resolution in practice, specifically the United Nations Commission of Inquiry on Human Rights into the DPRK, North Korea, which you chaired in 2013 and 2014. You have, as students will be very much aware, made a very significant contribution to the law in Australia throughout your long career, particularly during the 13 years when you were a judge of the High Court of Australia from 1996 to 2009, as well as in the high judicial and other positions you held before your appointment to the court. And since retiring from the High Court, you have been super active in so many fields, particularly in relation to human rights and healthcare issues, serving on many national and international bodies, including those associated with the United Nations, and as an arbitrator and mediator. You've also been closely engaged with many universities in Australia and overseas as a teacher, which is recognised by the fact that you are an honorary professor at 12 of those universities. In the case of the Australian National University, I note that the Centre for International and Public Law at the College of Law here holds annually the Kirby Lecture on International Law in recognition of your long passion for and service to international law. And this lecture, which will be held at the ANU later this month, on the 24th of August to be precise, is one of the most significant events in the Australian legal calendar. Michael, we're very pleased that you have made the time to be with us this afternoon, and we look forward so much to being in conversation with you. I would now like to invite you, if you wish to say any introductory remarks yourself, Michael, before we pose a few questions.
I also wish to pay respects to the First Nations people across our country. It's no good fixing up international problems if we don't, as far as human beings can, fix up the problems that we have in Australia with the First Nations people, including the problems in the law. Now, I was appointed to the chair of the Commission of Inquiry, as Richard has said, in 2013. I had two excellent colleagues from a different legal tradition, the Napoleonic civilian tradition. One was Marzuki Darusman, who was the former Attorney General of Indonesia, and the other was Sonia Basurko, who was a human rights civil society activist in Serbia, who'd had very close involvement with the issues of the Yugoslavia breakup. And we worked extremely hard on our Commission of Inquiry. We did it in a way that was unusual for the United Nations, which normally follows a rather secretive bureaucratic tradition, which it inherited in 1945, we insisted that, to the contrary, because North Korea was such a closed society, we would conduct our investigations substantially in public, unless witnesses found that that was too dangerous for them or for their family in North Korea. And so we held public hearings, we collected the evidence, we gave it all our consideration. We had an excellent secretariat, a very good head of secretariat. You often hear criticism of the UN, but I can only say that in respect of my engagement with the UN, and in particular on the report on DPRK, North Korea, the Democratic People's Republic of Korea, we had extremely able, talented, dedicated, committed guardians of the Universal Declaration of Human Rights and of the other international treaties on human rights. And all of it then came together in our report. Our report was presented by me to the Human Rights Council of the United Nations in March, the 17th of March, 2014. And it was sent by the Human Rights Council to the General Assembly, and exceptionally, it was sent by the General Assembly to the Security Council. That had only happened once before in respect of human rights issues in Myanmar, Burma. And there, to a very large extent, it still lies on the table of the Security Council of the United Nations. I'd like to say that we have had a big impact on human rights in North Korea. I don't think that can honestly be said. North Korea is a very closed society, and it refused to have any dealings with us. It condemned us and our report, but it didn't allow us, as we requested, the opportunity to go into North Korea. But we did the next best thing. We saw a large number of witnesses who had escaped North Korea and who were only too happy to speak truth to power and to come before the UN Commission of Inquiry on North Korea. And that is what this report. The United Nations is pretty good in organizing reports, but not very good in publicizing them. And that's why 10 years after we were set up, I'm here still endeavoring to capture the attention of the international community about the dreadful situation of human rights in North Korea. All reports indicate that that dreadful situation has not substantially improved. There have been tiny little improvements, but the fundamental problem remains a problem of an autocratic, secretive, and violent government, the government of Kim Jong-un, which kills its enemies and which ignores its critics. So that's the background of the report. There have been little improvements, but not good enough, in my opinion. And it's important for the international community to come squarely to face with that reality. The international community has promised that where human rights grievances are established to the level of crimes against humanity or genocide or war crimes, in those special cases of really grave human rights violations, the international community will not look away, because that's what the international community did up to the time when the United Nations was established. So it ought not to look away, it ought to get involved, and particularly because of the nuclear dangers and missile dangers that North Korea has developed even in the time since our report. So I think I've now given you an outline and a context, and I will be happy to answer any questions that Imogen or Richard pose for me to the best of my ability.
Very much for setting the context and providing that outline. I wondered if you could talk a little bit more about the challenges which the Commission faced, and also the methodology which the Commission adopted, and how you settled on that methodology.
We settled on the methodology at the first time that we three, the commissioners, met, which was on the 1st of July of 2013. We were actually appointed in February of 2013. A lot of work was done before that, including by the Secretariat. And when we got together at the Palais Wilson, which was the very place in which the first meetings of the League of Nations took place in Geneva, beside the lake in Geneva, we had to think about the methodology because we knew that North Korea would not allow us to go in. And they also would not permit ready access by telephone or Zoom links or anything else of that kind. They deny that to citizens of South Korea with families in North Korea, and they would not allow the United Nations High Commissioner for Human Rights or other special procedure representatives, and therefore we were under no illusion that we would be able to get in. And that's why when we had our meeting, I said we should be very transparent. We should involve the media. We should invite the media. We should have witnesses. We should organize public hearings. Those public hearings should be available to the international community on the internet. And if you go for a search on the Commission of Inquiry on North Korea, you will find the public hearings of the Commission of Inquiry there. That, as I said earlier, is unusual for the United Nations, but it was a desirable method of going about our inquiry. And we all agreed that this was the way, to the best of our ability, in default of an ability to go into North Korea, see for ourselves and ask witnesses on the spot. The way we adopted was tailored to the type of problem of gathering information that we had in order to discharge the mandate that was given to us by the Human Rights Council. That mandate included 9 heads of human rights violations, and we worked our way through all of them. We were unanimous in our conclusions. We brought our report in on time and within budget, and I think it's fair to say, without too much self-praise, that the report had a sensational impact on the UN system, because they'd never had an inquiry that had gone about things in such a transparent way. They had never had an inquiry that basically did the report in the way that we in common law countries tend to do reports. We do them by having public hearings and public inquiry. So my insistence on our methodology was not so alien to my own experience in Australia of public inquiries. And it was a very good methodology. And I have constantly said at large conferences and small conferences that this is something the UN should do more regularly, because it's a better way to gather testimony. But then, having gathered the testimony, we encapsulated it. And when we wrote on the right to food, or the right to free expression, or the right not to be removed from abduction to North Korea, or women's rights, or the other rights that are dealt with in our report, when we had all that done and wrote the report up, we did what we do in Australia with an inquiry. This wasn't a brilliant idea of mine. I was just following our own tradition and the Anglo-American tradition of inquiries. And so on every second page, there is an issue which we have dealt with, and there is then a quote from a witness. You see, a witness will be able to tell things more briefly and with power from their actual experience, and, let it be said, from their anger at having had been subjected to that experience and having had to seek to escape from North Korea. They were angry people, but they were overwhelmingly, in our opinion, the commissioners, truthful people who felt, well, we're not getting a voice in the International Criminal Court, but we're getting the next best thing, which is to a UN inquiry, which will reach some conclusions. And we want to speak to them. And so they did. And in our report, on every page, it's on the internet, there is, every second page, there is a quote from witnesses which deals with their experience, and it was on the basis of their experience and the principles of universal human rights that we produced the report. It's not only, I think, an accurate, honest, and balanced report. It's not only a report that didn't find everything that was given to us against North Korea. It had some matters where we rejected the submissions, but it's a report that is a good read. It's a great pity the UN doesn't have a better mechanism for making this report. They say, oh, well, it's on the internet. You can get it on the internet, but this should be on sale at every international airport near you so that people can buy it. It's actually to not just what we wrote, but to listen to the voice, the authentic voice of the people who have suffered terrible wrongs. It adds a power, and that was why it went to the General Assembly, where it gathered a very big vote in the General Assembly, and why, as we had requested, the General Assembly sent the report to the Security Council, which is a very rare thing for the Security Council to accept a report on human rights. They try to keep away from human rights, but with our report, it just couldn't be ignored because of the methodology which we had adopted.
Thank you very much.
Thank you, Michael. And perhaps if I could just ask a follow-up question on that methodology, because as you say, from a common law background, none of this was particularly unfamiliar to you. But I wonder if other members of the Commission from a civil law background needed a bit more persuading to adopt this methodology.
Well, we all knew North Korea was extremely secretive. It's called the Hermit Kingdom, and we all knew that we would not be allowed in. We knew that they had rejected many attempts by the UN officials to go into North Korea, and therefore we were under no illusions that we were going to have what you would normally get from a UN member country under the urgings of the UN member country, access. So I think that really affected my two colleagues. It was wonderful having three such experienced people in the area of human rights. My own experience as a judge in Australia, as a lawyer in Australia, but also as the former president of the International Commission of Jurists and other human rights activities and previous inquiries for the United Nations, inquiry on Cambodia, and activities on the struggle against HIV and other things. And my colleagues, we didn't debate this for very long. We met on the 1st, 2nd, 3rd, 4th and 5th of July of 2013, a full week devoted to methodology and what we wanted done. But we didn't carry a lot of time over this. It really was, as they say now, a no-brainer. It just was the only way we were going to be able to get authentic voices, and we knew that authentic voices would be our best weapon. And so we gathered the information. Of course, we were criticised. The witnesses were criticised. In one particular case, a witness's father was found who said, well, my son's given to telling lies and these are all lies. But too much of his evidence was confirmed not only by other witnesses, but also by satellite images. You can't hide anywhere in the world now, and satellite images bore out the complaints and bore out where they said there were detention places and prisons for political enemies. Google Earth found that, and so did security satellites from that were available to us. So we applied a high standard for the proof, but we were convinced by a great deal of the evidence on the wrongs, and all of this is set out and explained in our report.
And in relation to the conclusions, what would be the most perhaps controversial elements, if I can use that term, the ones that excited the most interest and comment?
Well, it wasn't controversial to say this should be debated in the Human Rights Council and in the General Assembly, and all of that was done. But we also knew that if our report got to the Security Council, and if we recommended action by the Security Council, there would be the problem of the so-called veto. The word veto is not used in the Charter of the United Nations. There is a requirement for the passage of substantive decisions by the Security Council for the participation of the 5 permanent members. And we knew that Russia replacing the Soviet Union and the People's Republic of China replacing the Republic of China would be probably going to withhold their participation. That created an immediate problem for our request that the issue be on the table of the Security Council. Would China and Russia veto that? But in fact, there was a little known provision in the Charter of the United Nations, which we knew, that said that on procedural matters, the veto didn't work. And therefore, in respect of a procedural matter such as the tabling of the report and consideration of the report by the Security Council, that could not be vetoed, but it had to be adopted by a 2/3 vote of the Security Council, and that was done. And when that was done, the report went onto the table of the Security Council, and that then became the foundation for the annual review of North Korea on a human rights issue and the annual decisions of the Security Council on the issue of the human rights of DPRK.
Thank you. And following that annual review, in addition to that, is there anything else that you think can be done by the United Nations or by the international community on this particular subject matter?
Life is never simple, and there's always complications. When we were appointed, the president of South Korea, the Republic of Korea, was President Park Jae-in, and she, as you probably know, was impeached and removed from office, and she was replaced by the president from a different party, and he became committed to a different course, and his different course was one of trying to secure cooperation from North Korea. You have to think of this in terms of Australia in the Second World War, where they had the so-called Brisbane Line, and it's as if that had resulted in the division of Australia, and a country with 1,000 years of history was divided. And it's understandable that there should be such strong feeling, yearning for reconciliation and rejoining the two parts of Korea, which never voted for separation. This was simply imposed upon Korea by the successful Allies in defeating Japan. And it came into force with the nuclear explosions over Japan, when Japan had to simply withdraw its occupying army from Korea. The Americans took the sphere of influence that had been assigned to them in South Korea. The Soviets took the sphere of influence that had been assigned to them in North Korea. North Korea was the industrialized and what you might say the progressive economy of Korea. South Korea was mainly a breadbasket. It was a place of agriculture, and it fed the peninsula. But in fact, as we all know, South Korea has become a fabulously progressive economy, and North Korea, except in one particular, has really had a very hard time economically, and as a result of that has a great problem, as we revealed in our report. I think it's the best chapter of the report, about food, access to food, a basic requirement of every society and of governments in every society, but one which has been neglected in North Korea. North Korea has become very advanced in one particular respect, and that is in the development of missiles and in the development of nuclear weapons. And this extremely impoverished, poor, ill-fed country has the fourth largest army in the world, and it has, even in the time since the report of the COI was delivered, it has produced a large stockpile of nuclear weapons. It's not large by the standards of the world. I mean, the Americans have got, the Russians have got the biggest, with over 1,000 nuclear weapons. But North Korea, it is believed, have about 50 nuclear weapons. And 50 nuclear weapons, as you would know, is enough to wipe out all of humanity. So, and the atmosphere, and the food chain, and all the other things that we rely on. So it's not a little mean thing. It does raise in your mind, doesn't it, that if a country so impoverished can produce missiles and nuclear weapons, what would Korea be like if it had not been divided? What would Korea be like if it was now united? It would be a real powerhouse of the economy of the world. They have obviously very good mathematics and science education in North Korea, but it's a country where they don't feed their people. And the issue is, how do we correct this? President Trump made two interventions in this issue. The first was his original speech to the General Assembly soon after he was elected president. And he then threatened North Korea that it would be obliterated. The United States would bomb it and deal with violence, which was itself a threat of activity contrary to international human rights. But then later he decided that he would try a different tack, and he sought to arrange meetings with Kim Jong-un. At the time, most people thought that that was a big mistake, that he should never have shown any interest in North Korea. He should have stood strong and firm against them. I myself thought that as standing strong and firm against them hadn't produced the goods. Maybe President Trump, by his exceptional and unexpected activities, had actually done something that might be very useful. But as you will recall, he had a meeting in Singapore with President Trump and Kim Jong-un. He had a meeting in Hanoi, which broke up on the second day. He met on the DMZ, the demilitarized zone, but they were the three meetings that he held, and they produced nothing. They produced nothing substantive. And he made an error from a point of view of the experience of diplomacy in the international level, which is, if you're in the negotiating mode, you start at the outside of the problem. You start at the little things where you can hopefully get some progress. Sister city arrangements, sporting links, reopening postal services, maybe permitting railways to be rebuilt and a railway service to be allowed once every month. But none of that was done. It was all straight. President Trump jumped straight into the absolute epicenter of the problem, which was nuclear weapons. And North Korea would not go along with him, and they would not surrender or submit their nuclear weapons to the control that he demanded. He then walked out of the Hanoi meeting, and the net result of that was that we made no progress. The West made concessions. The United Nations has not been able to correct the situation, and that's the position we are in. Speaking bluntly, it's an impasse, but it won't be solved by threats of violence, because this is a country that has lots of experience in violence and threats. And it's a quandary for the international community. How do we deal at the one time with human rights when even raising the issue of human rights causes a frenzy of animosity on the part of the regime in North Korea?
Thank you so much, Michael. I think in the light of time, we might turn to Q&A from the students if they have questions. I actually have a lot more I'd like to ask you, Michael, but I don't want to hog the microphone when we do have these international law students with such an interest in international law and international dispute resolution with us. So if I could, if you have a question, I'd ask you to put your hand up so I can see it on Zoom. If you can't put your hand up and talk where you are also welcome to put a question in the chat, and I can read it to Justice Kirby for you.
Now, don't be shy. This is the ANU, your top students in the whole nation. This is your area of special value and expertise. It's the great strength of the ANU College of Law. I think there must be questions about it. I insist on questions. Kim Jong-un would do the same. Questions are compulsory.
Absolutely, and you don't get a chance to ask questions of such an amazing special guest very often. Well, while we're waiting, I do have one that I would like to ask. Michael, this is just going back to your point about public hearings, but also about, I think, the really important point you said about it needed to be a legitimate voice, and it needed to be a voice that allowed people who had grievances to speak and that they were angry. And I was wondering if you found that the public hearings maybe made people reluctant to come forward, or if it was the opposite, that this provided an opportunity for people who felt they hadn't had a voice to not only tell their story, but to actually have it heard by others.
Well, that's a good question at the moment when we're thinking about what a voice means. Both were the reactions. Some reactions were from people who had suffered too much and they didn't want to become involved. Others were from people who had suffered and they had family in North Korea,
Mm.
and they were concerned that if they were seen, their image was seen, or if their identifiers indicated who they were, their family might suffer. And in those cases, we saw them privately and apart. We didn't film their testimony, but we used it. But the majority of people who had indicated their interest in the issue to the Human Rights Commissioner, the High Commissioner for Human Rights office, they wanted to give testimony. They wanted to come along. They wanted to tell the terrible wrongs that had been done to them and their families. There's something deep in the rationality of the human species that if you suffer, then you want justice, you want a response. And the UN, in its international human rights law, the Universal Declaration and the international covenants and the CEDAW agreement and the agreement against all forms of racism, all of these posit a response from the United Nations. And to have the system manacled in such a way that it can't move is really a terrible problem for humanity. I think all of us, I haven't seen it yet, but all of us should see Oppenheimer, the movie, because though it's a popular movie, it does present the activities and the ultimate self-criticism of Robert Oppenheimer, who was the chief scientist in the Los Alamos development of the nuclear weapon. And it presents to us a huge problem, which unless we as a human species can solve, will wipe us all out. I mean, that's the truth of the matter. Probably it won't happen in my lifetime, but it could well happen in the lifetime of the younger students who are listening. So it's an extremely important issue that we must solve. I mean, the Russians in Ukraine have various complaints. Some of them you don't see much about them in the Western media, but the complaints about Russian-speaking people who've been given away to Ukraine and whose children are being taught in Ukrainian. There is a solution. The right of self-determination of peoples is in the Charter of the United Nations. There must be a peaceful solution. But to blow up the world over mighty Russia and Russia's history is ridiculous. And it needs somebody to have a reality check, not only directed to Mr. Putin, but also to the Ukrainian leaders. I mean, we've got to get a sense of proportionality here. And unless the UN works, what other mechanisms do we have? And therefore, this is a really important moment of truth. It's a moment of truth for our species.
Absolutely, and it's a sobering thought, I think. I might ask Laura, who has her hand up, to ask a question.
Thank you very much for today, Justice Kirby. It's been fascinating to hear you speak on this particular topic. I was wondering what you see as, well, whether you see that any potential for non-government organisations or civil society groups to have any effect at those outside little things that you spoke of, those first beginnings of setting up, greater progress in a diplomatic sphere? Or is the border just too hard, too rigid, too closed?
Well, it's certainly very difficult, and there's no getting away from the problem. But at least getting the problem of North Korea on the table of the Security Council I think that was a very important victory for the Commission of Inquiry, because neither the Russian Federation nor China, both of which have borders with North Korea, can be very happy about the development of missiles that would easily carry weapons non-nuclear into Russia and into China. Neither of them can look with this lack of interest to this. And in fact, both Russia and China have agreed to resolutions which impose sanctions on North Korea. And that is something that they didn't have to do, and they could have held back. But when it came to our report, their representatives took different lines. The representative of the Russian Federation said, well, we understand our comrades in North Korea. We've been through all this ourselves, but we don't think that confronting them with their wrongs is the way to make the solution. And the Chinese said, we are opposed to single country subjects for commissions of inquiry or human rights activity. And so these are the issues we had to address. One sort of felt like saying, okay, wise guy, if this is not the solution, what is the solution? Because we must find a solution. But it's left to the nation states, and civil society has a definite role to play, because the civil society has a very strong voice in the council of the Human Rights Council, in the council meetings, and it is constantly badgering other countries, including African and Latin American, South and Caribbean and Asian countries that are very anxious about pursuing the issue. But civil society can and should snap at the heels of nation states and should be constantly reminding them of the Universal Declaration, which came out of the Second World War, and about the need to deal with the nuclear problem, which is itself a human rights problem, and to deal with all the other human rights problems that are identified and demonstrated, and I say proved, in the report of the COI. So I think we've all got to play a part. In Australia, we will shortly have to consider what we do about the ban treaty. This is the international treaty to ban the possession, use and threat of use of nuclear weapons. It has come into force now with the signature to the draft treaty of more than 50 countries. New Zealand has signed and ratified it. Thailand and other countries, peaceful countries in our region, have also signed and ratified it. Australia is in a quandary. How do we buy nuclear submarines from the United States? How do we shelter, so-called shelter under the umbrella, so-called umbrella of United States nuclear deterrent capacity? How do we get the benefits of nuclear deterrence by if we sign on to the obligation to ban the possession, use, or threat of use of nuclear weapons? So this is a problem that faces many countries, including our own, and it will face the governing party, because the coalition never favoured the ban treaty, but the Labor Party has had votes favouring the ratification of the ban treaty. So watch this space. It's going to be an important testing time for us And if feisty little New Zealand can sign, and New Zealand has its own treaty arrangements with the United States, it's a real question as to whether we simply proceed to deal with issues as a US ally, or whether, especially in a case of a country which is in our region, the Asia Pacific region, and with dangers that potentially threaten us, whether that gives a need to develop in international diplomacy a slightly more nuanced approach than we have had in the past. I think that's a very big issue on which civil society experts and citizen groups dealing with human rights should raise their voices. It's important in our democracy that civil society should be heard on what is ultimately an issue of survival of civil society and the whole human species.
Yeah. Thank you, Michael. Laura?
Thank you for taking the time to speak to us today. And I hope you'll forgive my ignorance surrounding this issue, but I was kind of wondering, what are North Korea's actual international legal obligations in terms of human rights? I haven't done my background research, I confess, but I'm not sure if they've signed into any of the treaties like the ICCPR. And I know that many of these rights aren't, or I think they aren't yet customary international law. So actually, what is the role of international law in, I guess, trying to address these issues in North Korea? Or is this more of a kind of soft law diplomacy approach? What actually can be done?
Well, the answer to that question is it is in part a so-called soft law approach, and there's nothing wrong with soft law. It can, if it's persuasive, and our survival as a species should be persuasive, it can have an effect, and it can mobilize support from members of the international community. But part of the solution, the answer to your question, is that North Korea has signed most of the important international treaties. It did so when long before the Commission of Inquiry was established, and when it appeared that issues of human rights were not just going to be ceremonial, but were going to have a substantive effect on the nation states that had signed the international treaties, like North Korea, they began to get a bit alarmed about that. And the net result was that they made an inquiry of the Secretary General of the United Nations, long before the COI was established, asking how they should go about renouncing or withdrawing from international human rights law, particularly the ICCPR. And I know the legal advisor at that time to the Secretary General. He is Judge Hans Corell of Sweden, and he had been a colleague of mine on an OECD committee on transborder data flows back in 1998 to 80. And he was the advisor on law to the Secretary General. And he recommended that the Secretary General answer the question by saying there is nothing in the ICCPR for denunciation of the treaty or withdrawal of the treaty, and therefore they can't renounce it. They can't withdraw. And that was the answer that was given. And North Korea has never challenged that. It has never renounced its signature and has been told by the United Nations that it can't. There is no withdrawal or exit provision in the ICCPR or other international treaties that it has signed. You don't have to be a member of the United Nations. But North Korea was very anxious to become a member of the United Nations, and it was admitted on the very same day as South Korea became a member of the United Nations in 1991, I think it was, or thereabouts. And so having joined, having signed and ratified international human rights law, the answer that the United Nations has given is you are bound. And under the new system of the Human Rights Council, there is the so-called Universal Periodic Review. This is a system of questioning countries about complaints by civil society, mainly concerning the non-compliance of countries with the international law of human rights. And North Korea has taken part in that, and it has answered questions. It hasn't simply stayed away or denounced it and said that they're not bound by it, notwithstanding the United Nations opinion. And to that extent, it's actually beneficial for us all, because North Korea has to be there. They had to be in the room when I presented my report. They attacked me, but normally what happens, it's a bit like the International Court of Justice. When people answer questions, the justices of the International Court do not simply have a dialogue with counsel. They have to give notice of the questions that they're going to ask. And this puts a sort of a limit on the spontaneity. But I was a judge from a common law country, and that's not at all the way we go about things. As you will see, if you go up the hill to the High Court and see the High Court conducting a case, and the same is true in America and in the United Kingdom and in South Africa and in countries, India, in countries of the Commonwealth. We are spontaneous and we ask questions, and lots of them. I asked a lot of questions. And so I was used to dealing with that system. And so when the North Korean and other allies, Cuba, the Russian Federation, China, made criticisms of our report, I simply made little notes to myself. And so when they had their say, they called on me, and I think they thought I would only speak to a brief that had been pre-delivered. But no way. I went one by one through the points that had been raised, and I gave them a little bit of common law treatment. I sought to answer the points, and I think that itself was a bit of a surprise. You know, it's not the way the United Nations normally operates, or the head of an inquiry for the United Nations normally operate. I think it'll maybe a long time before an Australian is appointed to chair a commission of inquiry in the future, because we are much more direct, we're blunt, we deal with the issues, and we try to come to grips with the problem of getting progress. And we must have this attitude because of the enormous dangers that face humanity from North Korea.
I think we have time for one more question.
Make it two.
Okay, two. Yeah, right, two. Thank you very much.
Kishon.
Kishon.
Thank you, Justice Kirby, for speaking with us. One of the things that I've kind of been reflecting on as you've been speaking is the accessibility of international law to law students. I think one of the things that Imogen raised in Advanced International Law last semester was the capacity for students to take action in international law now. We looked at the case of the Pacific students that were instrumental in submitting a request for an advisory opinion into environmental damage in the Pacific. In the context of nuclear arms and it being a live issue for a lot of us in our lifetime, what do you think are some, I suppose, things that students can do now in thinking about and responding to these challenges?
Well, first of all, students can become members of civil society organisations. I was always a member of civil society organisations. I was very big time in student politics. I then became very involved in the Council for Civil Liberties. I joined Amnesty International. I joined the Council for the ICJ, the International Commission of Jurists, and later the Human Rights Institute of the International Bar Association. So be a joiner. That's the first thing. Alone, well, there are real limits on what you can do. But if you can organise an international civil society organisation, they can not only put pressure on government to take steps, they can put pressure on politicians who have a say in our system, and they can urge that steps be taken, and they can make a lot of noise. In my time, at least, students made a lot of noise. Your generation of students are relatively quiet. They're such sweet little things, and they don't ever raise their voices. I think it's to do with HECS. I think you're also busy working part-time. You know, when I was an undergraduate, I didn't work. I just got the Commonwealth Scholarship, and that saw me through my whole course. And whatever the reason, students today are not joining as much, and they're not involved as much. So I like your question. It's good that you're thinking in those terms. But in respect of Australia, you could take initiatives under the ICCPR. There is now a provision whereby you can make an application to the Human Rights Committee of the United Nations, established under the ICCPR, and Australia has signed the optional protocol that permits a communication of this kind. And in the Toonen case, that is what happened. Although Mr. Toonen wasn't being prosecuted, he went ahead and complained to the Human Rights Committee, and that led to an extremely important decision, Toonen against Australia. And it was that decision that held that Australia was in breach of the ICCPR in the way it criminalised LGBT people. And that decision has had a very great effect in the world, in other countries. It did have an effect in Australia too, but it set the principle for the international rule of human rights law. So there are various things you can do. It's not the time, we don't have the time to go into them all, but the starting point is to be a joiner and to join political parties, to join civil society organisations, and to make a lot of fuss. Your future, really, if you just look at it objectively, do you think there's not going to be a mistake, an accident, a politician in a nuclear armed state who loses his temper? I mean, this is a really serious matter. That's why we should all be watching Oppenheimer. We should all be thinking about, puzzling about, and pressuring our politicians to come up with solutions that deal with the sorts of problems that are presented to the world by North Korea with its large missile delivery system and its extremely dangerous 50 nuclear weapons. One last question. Do we have time for a last question?
I think, well, we have one in the chat, so perhaps we'll take this as our last question. Michael, this is from Grace Hefferon, and it relates to actually one of the answers you gave earlier, talking about the Universal Periodic Review and North Korea's involvement in it, because Grace's question was, you know, following Trump walking out on the Hanoi conference, are there any mechanisms or conferences being organised to reinstate discussions with North Korean leadership and progress discussions on human rights?
Well, in fairness, the previous regime in North Korea put all its eggs in that basket and tried to get meetings between the North Korean leadership and the president of Republic of Korea. but the net result was nothing was done. No progress was made. During that period of that government, which was narrowly defeated by the current president of North Korea, South Korea refused even to sign on to the annual resolution condemning North Korea and calling for protection of human rights in North Korea. This was a really surprising stand when the country, which has relatives and members of families and so on in North Korea, was silent at the meetings of the General Assembly and on the Security Council. That's changed with the change of regime in South Korea, but getting action is the difficulty. But that doesn't mean we should be silent. That doesn't mean we should ignore the report and put it on the shelf and forget about it. It's too stressful and dispiriting and anger-raising to read the report and not to do anything about it. We tried to make this a passivity immune report. You cannot read the report of the Commission of Inquiry on North Korea without feeling this is really dreadful. Something has to be done. But under the Charter of the United Nations, the most important thing which we recommended, which was that the Security Council should refer the matter to the International Criminal Court, that cannot be done because that is not a procedural question. That is a substantive question. And on that, it has to have the affirmative votes of the 5 permanent members. So we've just got to appeal to the better natures and the sense of proportion and the sense of survival, the hope for survival of humanity. And we've got to keep at it, and we've got to lift our voices and not put a report like this or other reports on similar issues in the little bottom drawer because it's all too hard. We've got to find solutions. And when we give up on that, we give up on the security of our future as a human species.
Absolutely. Well, we have come to the end of our allotted time and then some. So please, would everyone join me in thanking Michael Kirby for his time, his expertise, his wisdom. We appreciate it so much, Michael, and we are so grateful that you give this opportunity to our students.